May it please the court, my name is Russ Baldwin. I'm joined at the council table by Murphesboroughgh. Together we represent the appellant, Amsurge Unenforceable, Inc. With the court's permission, I would like to reserve 4 minutes for the moment.
Got it.
This is a contract dispute governed by Tennessee law. The issue before the court is whether a Tennessee case known as Murphesboroughgh Medical Clinic renders unenforceable certain ownership and investment restrictions that the appellee, Dr. Banghera, entered into in connection with the sale of his former business to Amsurge. The trial court entered summary judgment dismissing Amsurge's effort to enforce those ownership and investment restrictions, and it did so exclusively on, or based on, the Murphesboroughgh decision. We respectfully submit that the trial court's order was erroneous and should be reversed. Our position is straightforward. Murphesboroughgh is inapplicable here. It has nothing whatsoever to do with the restrictions or with restrictions of the type that are present in this case. And further, the public policy underpinnings of the Murphesboroughgh decision do not extend to the ownership and investment restrictions here, business restrictions. Those business restrictions are of a different type under Tennessee law than the employment restrictions that were present in the Murphesboroughgh case, and I'll walk the court through that, but we have substantial case law on that. Let me begin, however, with just giving the court some background on how we got to this dispute. Amsurge was formed to develop and operate ambulatory surgery centers, or ambulatory surgery facilities. That's its only business. It doesn't provide any medical services. It provides facilities and equipment for physicians in the community or anywhere, really, to come in and use those as the physicians may deem necessary and appropriate. Dr. Banghera wears a couple of hats. Dr. Banghera is a medical doctor and does provide medical services, GI services. Sorry.
It's all right.
It's a mouthful.
It is.
And it's late. It's at least mid-morning.
That
anyway.
That is not his only hat. He's also a businessman, and in his capacity as a businessman, which is relevant here, we submit, he has developed and owns, or has owned, at least 4 separate of these ambulatory surgery center businesses, totally separate and apart from his role as a physician. The parties' relationship began in 2007. At that time, Dr. Banghera and several of his existing business partners at the time sold to Amsurge 51% of the assets of Dr. Banghera's former surgery center business. Amsurge paid some $2.4 million for those. The parties contributed all of the assets, both Amsurge's 51% and the remaining 49 left with Dr. Banghera and his other business partners, to the formation of a new joint business venture known as the Newport Richey, Florida Multi-Specialty ASC LLC. I think it's the only LLC involved, and I will refer to it as the LLC. The LLC's business, as I mentioned, is, like Amsurge, is to provide ambulatory surgical facilities and equipment for physicians or medical providers in the area who may want to come in and schedule a time to do a procedure that, for whatever reason, they don't want to do in a hospital or somewhere else. The LLC gets paid basically on a per-use basis. So when a physician comes in, schedules a procedure, the LLC charges a facility fee for the use of that procedure room and or whatever specialized equipment the physician may require for that particular use. As a part of the business transactions between Amsurge and Dr. Banghera and others, they entered into an asset purchase agreement as well as an LLC operating agreement. Both of those contracts contain similarly worded ownership and investment restrictions entered into in connection with the formation of that business. Those ownership and investment restrictions provide that the sellers, including Dr. Van Gera, would not own, manage, lease, develop, or otherwise acquire a financial interest in a competing business within I think it was 15 miles of the center business time period deadline set out in the agreements. Despite those assurances, Dr. Van Gera, by the spring of 2010, about 2.5 years later, the LLC and AMSER learned that Dr. Van Gera had in fact built out and developed a competing business in some commercial property that he owned adjacent to his medical office. Both the LLC and AMSERG reminded Dr. Van Gera of his obligations and demanded that he cease and desist the violation of the ownership and investment restrictions. He refused, and AMSERG filed this litigation. Separately, the LLC had a contractual remedy to buy out Dr. Van Gera's interest in the LLC.
$1.
Yes, sir. Yes, sir. And the LLC invoked that, but AMSERG didn't have a remedy like that, and so it brought this litigation to enforce the restrictions in its own right. In response, Dr. Van Gera has argued and continues to assert that the Murphesboroughgh decisions categorically void any and all contractual restrictions involving a physician. And respectfully, we submit that that is not what the Murphesboroughgh decision says or what it stands for at all.
Murphesborough, that's the case that his term of employment had expired and the hospital elected not to renew him, right?
I'm sorry, I didn't.
In Murphesborough, the doctor's contractual term of employment had expired.
That's right.
And then the hospital elected not to renew him. When he applied for jobs at other hospitals, they refused to allow him to compete, if you will.
That's right. And the physician there was an employee of the hospital system in Murphesborough. There's no employees involved anywhere here. Dr. Van Gera is not an employee of the ambulatory surgery center business or the LLC. He's an investor and an owner of that business, of that entity, but he's not an employee of it. I'm not sure if they're legally able to be to employ physicians. I know hospitals do, but at any rate, he's not an employee and never has been. And so my first argument is that the Murphesboroughgh decision is simply on its face inapplicable. The restrictions at issue in Murphesboroughgh had to do with employment, a physician's right to practice medicine or to be employed by a competing hospital or a competing business of some sort for the purpose of practicing medicine. Those restrictions are different in kind under Tennessee law from the business and investment restrictions that are at issue here. And let me say just a little bit on Tennessee law on this point. Tennessee law recognizes and treats differently at least two fundamental types of restrictive covenants. Those that address employment restrictions or a person's ability to engage in their occupation on the one hand, and those that restrict business transactions on the other. Restrictions on employment raise public policy concerns, separate and apart from whether or not it's a physician. Just restriction on employment altogether raise public policy concerns, and under Tennessee law, those types of restrictions are strictly scrutinized. Restrictions like those here on commercial business transactions do not raise those same sorts of public policy concerns, and in fact in Tennessee are presumptively valid. There is a rebuttal presumption of validity to those types of restrictions. That's in Tennessee Code Annotated 63-1-148. It's in the Greene County Tire case cited in our brief and others. As I've said, I sound like a broken record, but Murphesboroughgh only addressed the restrictions on physician employment. And that was the public policy concern when it applied to a physician in particular that caused the Murphesborough court to say, we're not going to restrict physicians' employment or their ability to practice medicine. We think there's a greater public good. Now, Murphesborough has subsequently been overruled by statute, whether that's not the public policy of Tennessee according to the legislature anymore, but at least there was a good public policy argument of why you wouldn't restrict a physician from being able to practice medicine because it provides a public good. That's not the case here. This case involves only the second type of restrictions, which are restrictions on a businessman's, who happens to be a physician in this case, ability to sell to AmSurge a business and then say, agree that he will not go out and develop or acquire an ownership in a competing business. Separate types of restrictive covenants under Tennessee law, treated separately by the Tennessee courts, and only one of them was at all involved in the Murphesborough decision. And that, I mean, it's clear on the face of the Murphesborough decision. It's clear as the Murphesborough court states the issue. It says the issue presented in this case is whether a covenant not to compete is enforceable between a physician and his former employer. It's clear from 100% of the authorities and arguments in the Murphesborough decision deal exclusively with physician employment or restrictions on physician employment and physician ability to practice medicine. Murphesborough nowhere addresses the business activities of doctors outside of their practice of medicine. It certainly doesn't provide physicians with some special privilege in their business activities that would not apply to other businessmen in the marketplace. For those reasons, in short, the Murphesborough decision just simply doesn't on its face apply here. The court didn't consider the type of restrictions that are at issue here. It certainly could not have adjudicated them, and it didn't. The next argument is, well, you might say, okay, this is restrictions that do, at least in some sense, involve a physician. Should the Murphesborough holding be extended? Well, Murphesborough holding shouldn't be extended for a couple of reasons. One, it's been legislatively overruled, so therefore it doesn't represent the policy, public policy of the
Was
state.
legislative ruling after this contract was signed?
It was legislatively overruled. The statute was passed just prior to this contract being signed. The contract was signed in October 2007. The statute was passed in June or July of 2007, effective January 1st, 2008.
Okay.
And there's, I think, a solid argument that being a remedial statute in Tennessee would be retroactively applied. Under Tennessee law, remedial statutes are retroactive. But our position is simply that it never applied in the first place. The Murphesborough didn't apply to this context in the first place, and so whether or not it was retroactively applied, the statute repealing or effectively overriding Murphesborough is kind of a non-issue. So I was going to talk about the public policy under Murphesborough. As I've said, and it's very clear throughout the Murphesborough opinion, the entirety of that decision is based on a public policy argument that restricting physicians' ability to practice medicine is not in the public good.
I'm curious because I have Judge Mills's order here. He doesn't really explain in detail why he thinks the Murphesborough applies. He just says, he comes to a conclusion that it applies to the facts. He doesn't even explain why.
And Your Honor, I wish I could give you more color on that. Unfortunately, I wasn't involved in the case at the time. And so I wasn't there firsthand. And I've only got what you have, which is the order. And frankly, I mean, Judge Mills, I thought, did a wonderful job in this case. I think he looked at Murphesborough and said, well, it involves restrictions on a physician. There's a physician involved here, and there's restrictions, so it must apply, and that's what he went with. And whether it was our fault for not explaining it better, I don't know. But I really just can't answer your question as to any further detail about what Judge Mills was thinking about that.
Okay.
So the public policy was, underlying Murphesborough's decision was, we don't want to preclude doctors from practicing medicine. That public policy does not apply here at all, because nothing in the ownership and investment restrictions would in any way prevent Dr. Van Gera from practicing medicine. In fact, the ownership and investment restrictions specifically preclude, because he was a doctor, and you didn't have to be a doctor. Obviously, Amherst wasn't a doctor to invest in this, but he was a physician, and so we recognize that. And the ownership and investment restrictions provide that they would not prevent him from, quote, engaging in his profession, the practice of medicine. So Dr. Van Gera recognized that when he signed the restrictions, and it's self-evident from the restrictions themselves, because they only limit his ability to invest in a competing business.
You're at 16.
Okay.
It's your time. You can keep going if you want.
No, thank you. With that, subject to, of course, questions, I'll reserve the remainder of my time.
Okay.
Good afternoon, and may it please the court. Latasha Johnson of the law firm Ehrenstein, Charbonneau, Calderon, representing the appellee, Dr. Srinivas Prasad Vengara. I'd like to start my argument where I believe the court will end its analysis, and that's with the clear holding of the Murphesboroughgh decision. We hold that except for restrictions specifically provided for by statute, covenants not to compete are unenforceable against physicians. There are no caveats, there are no restrictions, there are no limitations as to context. It is a clear statement that all non-competes against physicians are unenforceable. Now, counsel representing AmSurge would have the court believe that when the Tennessee Supreme Court rendered this holding, it wasn't thinking about all the myriad of hats that doctors wear. Counsel correctly pointed out that Dr. Vengara wears several hats. Yes, he's a physician. Yes, he is a businessman. He's also a dad. He's also a lot of other things. He's wearing a lot of hats. We don't dispute that. But to imply that the Tennessee Supreme Court didn't realize that doctors were also businessmen, as well as physicians who practiced in the community, is to do this opinion a great injustice. Every question raised by counsel in his argument is addressed by the opinion itself or the sources. And that or the sources is really key in determining whether or not there is some sort of limitation on this holding that would make it not apply to a corporate agreement.
How about the argument that was made, Ms. Larson, that the case really involved a doctor, a physician who was employed, and that's what the holding was dealing with, that as opposed to other matters like this, investment and so forth. Can I just have you address that?
Yes, Your Honor, I will. The opinion goes through all of the different ways that these types of restrictions can arise. First, I want to point out that this investment restriction is an investment restriction that is running parallel and tethered to a non-compete covenant. There is a restrictive covenant built into it, and you cannot separate the two, because otherwise there's no enforceability of the investment restriction. So it is a non-compete covenant, let there be no doubt. Now, what the Murphesboroughgh court did was looked back and reflected on all the ways this comes about. They relied on the American Medical Association Ethics Opinion 9.02. That's very helpful here, because that opinion, that ethics opinion, addresses employment, it addresses corporate agreements, it addresses the effect and the discouragement of non-competes as it applies to physicians without scope, without limiting it to just employment. So when you look at the American Medical Association opinion and you see that the American Medical Association pointed out, I'll read it for your honors.
But if, I know what you're saying, but to take that case to an extreme, that means if you have an individual who decided to purchase McDonald's as a franchise, then somehow gets sued, somehow there's a non-compete associated with that, and that person happens to be a physician, to take it to the extreme of that case, listening to your argument, that would also apply to a physician who decides to own a McDonald's. Doesn't that kind of
Respectfully,
make no
Your Honor,
sense?
I understand the court's concern, and I would say that I would submit that it wouldn't apply to a situation if we're just talking about a McDonald's. We're talking specifically within the context of the medical profession, and that's within the body of the opinion as well. One of the things that stood out to me in preparing today was the court's reliance on cases even that were not even Tennessee cases. Like, they really did a lot of research in rendering this opinion. One of the things that they pointed out was a dissenting opinion in a case that goes back to 1988. The case is Shankman versus Coastal Psychiatric Associates. It's a Georgia case. At page 368 of that case, the dissenting judge, Judge Smith, says, and I'll give you just a little bit of the background. What he's talking about here is applying a non-compete covenant against a physician. He says, this is what happens when the court allows doctors to become businessmen instead of healers. Rules that govern tradesmen in the marketplace are of little relevancy in dealing with physicians who hold themselves out as experts and whose practice is regulated by the state. That is quoted, that same passage is quoted in the Murphesboroughgh decision. That tells this court that the Tennessee Supreme Court knew very well that doctors can also act as tradesmen, and was specifically saying they should not be treated the same. And it wasn't just doctors, it was doctors and lawyers who, because of the services that they provided to the community, were singled out. So, to answer Your Honor's question, it wouldn't apply in the context of, ownership of a McDonald's. If that were the case, then none of the other public policy concerns would be implicated. Now, the other thing that I want to address is to suggest that this ownership restriction doesn't restrain Dr. Vangara from practicing medicine. It's just false on its face because of the way that we ended up here before this court. What happened in this case is, yes, he entered into this agreement, business partners with the appellant. They believed he was competing against them wrongfully. His position is he wasn't providing any medical services that were in competition with the LLC. That's his position. We've never gotten to the merits of that because we have the Murphesboroughgh decision telling us that all of these provisions should be void on their face. But that's his position. Nonetheless, what has happened is, because of the mere accusation, he's been drawn into litigation. It has absolutely affected the patients that the Murphesboroughgh decision is intending to protect, and it has implicated all sorts of questions as to what he can do for particular patients that would not violate this agreement that he's got with AmSurge. So just the facts of this case and how we came to be here on appeal demonstrate that this is not just a mere investment restriction. It's an investment restriction that runs parallel to...
I don't understand that argument. How does this litigation impact a separate freestanding ambulatory surgical center that, as I understand it, multiple doctors used? It's not just, wouldn't be just used by Dr. Vangara. He'd have anybody that wanted to could come in and use the services. So how's this impacting patients? I don't get it.
I'd like to just, clarify a bit. The allegations here are that Dr. Vangara has a separate office outside of the ambulatory surgery center where he's seeing patients that don't want to be seen at the ambulatory surgery center. So it creates a conflict between whether those patients have to go to a facility that they don't want to go to versus the private office of Dr. Vangara. And that's one of the things that's raised, in the lower court in our pleadings, is that a lot of what happened that we believe is a misunderstanding is that there are plenty of elderly patients that Dr. Vangara services, and that those patients were having a hard time going to the ambulatory surgery center for various purposes, and that they found it more expensive, so they preferred.
Is there a provision in 8.2 that says the parties acknowledge and agree that this section does not require the physician owners to perform surgical procedures at the center or to refer patients to the center? So how does this impact his decision? He can send them anywhere he wishes.
Well, that's what happened, but we were sued for it anyway. I think that's exactly the point, Your Honor, is that supposedly the investment restriction allows him to do this, but that's not what ended up happening in practice, and that's not the manner in which they attempted to enforce it.
Okay.
Carrying on.
You said this wouldn't apply to a doctor who owned a McDonald's, but it does apply to an ambulatory surgical center. I just wonder where you would draw the line. What if a doctor owned a medical supply business? What if a doctor owned a business that had a computer program for electronic medical records? Where's the line get drawn here?
We would draw the line, Your Honor, with all due respect, to where the Murphesboroughgh court, we think, drew the line, which is if there is a non-compete that restrains the physician's medical practice. If we have a case of
if that's the answer, then I don't understand your argument then, because I don't see how this restrains Dr. Vangara's medical practice at all. It's simply he sold an interest in a business, he got some money, and they said, we're going to pay you this money, but we don't want you to go out and start competing against us. How does that restrict his ability to practice medicine?
Your Honor, we would argue that on its face, it should not. It should not restrict his ability to practice medicine, but because of the fact that it was, one, applied that way by the managing member, which is here as the appellant, it actually, in effect, did have that. But I would submit that the court doesn't have to get there because it's void on its face. So even though, I guess the answer is twofold. One, it affected his practice in actuality, because that's what transpired by the manner in which it was enforced. And I guess one thing that might help clarify this for the court is, at the record volume 2, 362 to 373, there's a series of letters written by AmSurg. When you read what the letters are alleging, it's quite clear that it's the performance of medical procedures that they believe compete with the business of the LLC, which are at issue. It's an investment restriction that is running with this competition of the doctor performing services that they believe compete with the LLC.
Let me ask you this question, Ms. Johnson. Doctors are businessmen, whether we like it or not, and they own surgical centers and dialysis centers and all these different things. And when they go to sell them, generally, in these type of transactions, people don't want to pay a bunch of money to buy an existing business and then have the seller go across the street and open up a business that's going to compete with them. So they ask for, a non-compete. Isn't the position that you're arguing here for Dr. Vangara going to adversely impact other doctors who might want to sell businesses? Because why would a buyer pay a bunch of money and not be able to prohibit the seller from competing?
Your Honor, you raise a good point, and I believe that's why this was subsequently overturned. I mean, what happened is, the opinion says what it says, and it is as broad as I'm advocating that it is, by its plain language and by the sources. I mean, there's numerous cases cited by the opinion dealing with not only employment agreements, but corporate agreements as well. So this court clearly knew this.
But your argument asks us to, number one, ignore the facts and the context in which this opinion arose and was written, and number two, to assume that the justices that wrote the opinion didn't have, you know, weren't able to look at the larger picture and see that somehow that buying and selling businesses was different from restricting somebody from their ability to practice medicine.
I understand the court's concern, Your Honor, but they addressed it. I mean, when you look at the Judge Smith dissenting opinion that they cite to, he addresses this concept of physicians as tradesmen and clearly discourages it, and they adopted it.
That's in the dissent?
That is in the dissent of the Shankman v. Coastal opinion, but it's cited and quoted within the Murphesboroughgh decision. So Your Honor's points are well taken, but the Murphesboroughgh court recognized them and chose to do this anyway. And this is the result. I think there was a tremendous pushback from the legislature, obviously, which ended up making it so that this ruling no longer would apply. This concern would be limited to really only the contracts that were entered into during this very brief period in time between 2005 and 2008, when the new statute became effective. I think that Your Honor is pointing out good points with respect to how broad or how narrow, you know, a prohibition against restrictive covenants should be, but respectfully, that's not what this court did. Ultimately, I think it's why it was reversed by the legislature. But when Your Honor looks at the language within the case itself and all of the sources, and I've pointed out at least two, but I would submit that in our papers we've got a string cite of at least 4 cases that deal with this outside of the context of an employment agreement, and that would apply in the situation here with Dr. Vangara. So when you look at it, really the only question that this court has to answer is if Dr. Vangara's contract that he entered into would fall under the Murphesboroughgh decision, and the answer I would submit is yes, because of all of the reasons inside the opinion itself, which address doctors as businessmen, doctors as practicing physicians. They fully knew. One of the decisions that's relied upon by opposing counsel was a 2000 case. It's called Biomedical Applications of Tennessee v. Chari. That case is a case that pretty much stands for the proposition espoused by opposing counsel when he says, well, you treat these two things differently. You treat an investment restriction that has a non-compete attached to it differently than you would an employment agreement. That information was available to the Murphesboroughgh court, and nonetheless, they still didn't temper the language with respect to its holding. So they had it there, they knew about it, they overlooked that case, which makes this delineation between the two, and they jumped back 20 years to go to 1988 to pick up on Judge Smith's opinion, which is that
Is there any Tennessee decision, whether it's from the Supreme Court or any intermediate appellate courts they have, that applied Murphesboroughgh in the context of the sale and purchase of a business such as we have here?
Well, there are a couple of cases, Your Honor, that cite the Murphesboroughgh decision. None of them in the context of, I don't want to misstate anything. I don't know the answer to your question with respect to if they're applied in the exact same way we have here, but what I will tell you is that the cases that do cite it for the proposition of the broad holding. It's not narrowed to just an employment agreement. Like when it's cited, it's pretty much described the same way the dissent in the Murphesboroughgh decision reads, which is quite clear that it is anything that's not allowed expressly by statute that would be rendered void and unenforceable. In fact, that's really why the dissent in the Murphesboroughgh opinion exists, because they felt that it was too broad an application and really advocated for what the prior position had been, which was that you use an analysis relying on reasonableness, temporal limitations, scope, and things of that nature. But that's not what the court did. And when you read the dissent to Murphesboroughgh, it points out that this is so broad that it's everything that's not expressly permitted by statute. And so that's where we are, and that's the holding, and it is applicable. We address also, Your Honor, in our papers, in the lower court, our motion for summary judgment, why the case is still applicable. One of the things that I noticed opposing counsel mentioned was that it was subsequently overturned by a statute effective January 1 of 2008. We addressed Tennessee law on that issue in our motion for summary judgment, and because there is an express effective date for the statute, it is not retroactively applied. It only moves forward. And so, the case law for that is obviously within the papers. But I think, the other point that I would like to make, Your Honor, and I'll start to wrap up, is just that the public policy concerns that were raised by Murphesboroughgh were not merely related to the patient's right to choose a physician, or the fact that, the courts didn't want doctors to be, have difficulty in transferring patients from one place to the other. The anti-competition aspect was also key. And that is, again, in the American Medical Opinion 9.02, where it says that these types of restrictions, and again, this is employment, corporate, all types of agreements, that they discourage these opinions because of the effect that they have on competition. And the court liked that so much that the Murphesboroughgh court liked that so much that they actually cited it twice. The Murphesboroughgh opinion cites it at page 679 and 684, talking about the restriction on competition. So it's not just the restriction on, the burden that it places on the patients. It's the anti-competitive nature of it, and that's exactly what's happening in this case. This is a case where they're saying, you're competing with me. You have a medical office that you are seeing patients in that is competing with me. So that I
take issue with you on the seeing patients, because I assume that the doctor sees his patients in his office, and then he and others may, from time to time, use the surgical center to do certain procedures, but I don't think that's the same thing as, quote, seeing patients.
We don't either, Your Honor, but that's one of the issues of fact that we never addressed, because our position was that you only have true competition, true competing with the LLC and the ambulatory surgery center, if you're performing the surgery procedures that have tray fees and that are described inside of the operating agreement for the LLC. If you don't have those aspects, then we're not truly breaching any agreement, because then you're not really competing. You're allowed to see patients, as Your Honor points out. But I think this all goes back to the heart of the dispute, is that when you try to parse out these different little pieces of, well, when is it going to be, when should the non-compete be void, or when should it be enforceable, the Murphesboroughgh decision didn't want the courts to go there. They wanted it to be a broad application. And so that's why it ends up being a direct effect on someone like a Dr. Vangara, who has this agreement that he's entered into, has a situation where he doesn't believe he is competing, but is nonetheless, it's alleged, and it does in fact end up disrupting him seeing patients in his office because of the accusations by the other business members.
Thank you. Your time has concluded.
Thank you.
Your Honors, not surprisingly, I would respectfully disagree with Ms. Johnson on a couple of points, several, but